Good morning, please be seated. Ladies and gentlemen, calling the case of the public prosecutor versus Hanif and others. This is a criminal case alleging that the defendants, Hanif and Justin, illegally kidnapped Muhammad Aaron bin Aziz, a 17-year-old boy, and they are also guilty of murdering the kidnapped kid. You will be instructed by the law at the end of this case. You need to know from the outset, however, that it is up to the public prosecutor to prove beyond a reasonable doubt that each defendant is guilty as charged in the indictment, based solely on the evidence you will hear in this case and not based on any preconceived notion of guilt or innocence of the parties or anything you may have read in the past about Hanif or Justin. Are both sides ready?
Ready, Your Honor.
Ready for the defense, Your Honor.
Because the public prosecutor must prove guilt beyond a reasonable doubt, it is up to the public prosecutor to proceed first. So you will first hear the opening statement of the public prosecutor, and then you will hear the opening statement of the attorneys for Hanif and Justin. After opening statements, you will then hear the public prosecutor's witnesses, and after that, either or both defendants may call any witnesses they choose. Any witness called by any party may be cross-examined by any other party. After you hear all of the evidence from the witnesses, you will then hear the closing arguments. First from the public prosecutor and then from the attorneys for the defendants. Is the public prosecutor ready to proceed?
Yes, Your Honor.
Is the defendant Hanif ready to proceed?
Yes, Your Honor.
The state may proceed with its opening statement.
Ladies and gentlemen of the jury, in the opening statement, it is my duty to tell you what the evidence will be. I will tell you what we will prove. We will prove that Mr. Hanif and Mr. Justin both are guilty for kidnapping and murdering the deceased. Members of the jury, Mr. Hanif and Justin both have been charged in the one-count information with the crime of kidnapping and murdering in violation of Penal Code. The information alleges that on or about May 5th, 2004, the defendants, Hanif and Justin, did kill the deceased in violation of Section 302 of the Penal Code, right together with Section 34 of the same code for having murdered a 17-year-old kidnapped victim, and Section 3 of the Kidnapping Act 1961, right together with Section 34 of the Code for kidnapping the victim for a ransom of 20,000 ringgit, Malaysia. To this charge, Hanif and Justin have entered a plea of not guilty. The evidence I present will prove to you that both defendants are guilty as charged.
Your Honor and ladies and gentlemen of the jury, under the law, my client is presumed innocent until proven guilty. During this trial, you will hear no real evidence against my client. You will come to know the truth that Mr. Hanif was not guilty for murdering Aaron, who is the boy that they kidnapped. Hanif and Justin do not have any close relationship, let alone to do the act together. Moreover, it is clear that Hanif's shift or work time is between 10:30 a.m. to 2:30 p.m. and 5 p.m. to 10:30 p.m. Thus, it shows that he has limited time to even do something else. Therefore, my client, Mr. Hanif, is not guilty for kidnapping and murdering the boy, Aaron.
Public prosecutor, you may call your first witness.
Your Honor, the public prosecutor called Puan MIKYAL, the mother of the deceased.
My name is MIKYAL binti Muhammad RAZIN.
Please be seated. So, Puan MIKYAL, you're the mother of the victim and now the deceased?
Yes, I am.
Okay, so Puan MIKYAL, when was the last time you saw your son and at what time did your son leave the house?
Aaron left the house at about 9 p.m. on 27 April 2004 and he did not return home after that.
Puan MIKYAL, the next following day, which dated 28 April 2004, did you receive a phone call from a number identified as Aaron's mobile number, which is 016-953-7893?
Yes, that's true.
So, in what language did the caller speak and what were the words uttered by the caller?
Caller apparently spoke in Bahasa Melayu but with an Indonesian accent and he said to me that anak awak ada kena ikat, saya mahu RM20,000.
So Puan MIKYAL, you said that he asked you for a ransom money for an amount total of 20,000 ringgit Malaysia. That means the call came from a guy.
Yes, that's true.
Okay, Puan MIKYAL, was there another call made between you and the other party? And was there any negotiation made between you and the other party regarding the amount of ransom money demanded?
Yes, half an hour later I received another call and we talked and negotiated about ransom money demanded by the caller and we finally agreed on the amount of 10,000 ringgit.
Okay, so did you prepare the ransom money demanded by them?
I did. I communicated with my brother Imran who lived in Kuala Lumpur. At about 10 p.m. I lodged a report and on 29 April 2004 at about 3 p.m. I received a phone call from the same number inquiring about the money.
Alright then, did you give them the money? And if yes, where did you meet them?
No, I did not meet them. Instead, I received another phone call to instructed me to wait at the Petronas station situated in Jalan Air Putih. I wrapped the money in newspaper as the caller instructed me to do it, but even after 15 minutes, no one appeared.
Did you receive another instruction from them?
I saw someone who was proceeding slowly on a motorcycle and received a call where I was instructed once again to proceed to the previous Petronas station, and this time, having waited there, I received another phone call and instructed to proceed to Jalan Air Putih where a video entertainment center was located, and I was told to place the money in the toilet in the center.
Okay, Puan MIKYAL, after you follow all the instruction given by them and hand them the ransom money demanded, did they return Aaron to you?
No, Aaron never returned until I received a phone call on 5th of May from the police to identify my son's body.
Alright, no further question, Your Honor.
Defense counsel, you may cross-examine.
Thank you, Your Honor. Puan MIKYAL, you said that you received an unknown phone call from a phone number identified as the deceased's mobile number, right?
Yes, I did.
When you answered the phone call, did you recognize the voice of the one who called you?
No, I did not recognize his voice. What I know is that the caller is a guy and he spoke in Bahasa Melayu with an Indonesian accent.
You said that you did not recognize the voice. That means you do not even know who the caller was, right?
Yes, that's true. I only contacted him through a phone call a few times.
Do you ever meet him in person?
No, I never met him.
When you arrived at the Petronas station, you said that you saw someone who was proceeding slowly on a motorcycle. Do you possibly think that the person may be the guy that called you?
Yes, it is because his act seems suspicious.
Do you, Puan MIKYAL, by any chance see that person's face?
No, I did not see that person's face.
Okay, alright. No further question, Your Honor.
Ms. Huda, you may step down. Next witness, please.
The public prosecutor called an expert witness, Inspector Nizam.
My name is Muhammad Nizam and I am the inspector in charge for this case.
Okay, Inspector Nizam, when was the first accused arrested and who arrested him?
The first accused was arrested early in the morning on 4th May 2004. The arrest was on my instruction to Officer Muhammad Noor and his fellow officers. I ordered them to track down and arrest the suspect. The suspect was taken to the D9 office. Some initial questions were asked and then they are taken to the Kuantan IPD. Preliminary question about the case. The suspect was taken to the IPD to lodge a police report and hand it over to the IO. Next, the suspect was locked up. I met him at 11 AM on 4th May 2004. I was informed by Inspector Williams that 2 suspects were remanded for 14 days. I met the suspect at the CPG at the IPD office.
Did you talk to the accused?
At that time, I was with Officer Muhammad Noor and Assistant Superintendent MIKYAL. Suddenly, the accused requests to talk with Assistant Superintendent alone about something. I was allowed it, and not long after that, the accused with Assistant Superintendent followed by me, went to Pantai Terung.
Alright, then what was the accused, the SP call and you did over there?
Right there, the first accused brought Assistant Superintendent and showed him where the victim was buried.
Alright, no further question, Your Honor.
The defense counsel, you may cross-examine.
Mr. Nizam, when you investigate Mr. Haniff, how did he react to your question?
He reacted with my question calmly and as if he were innocent in this case.
Did he show any sign that he does not understand what you said?
He looked clueless when we asked him in Malay language. Then he requested to talk with Assistant Superintendent as he can understand the Cantonese language.
Mr. Nizam, can you describe what do you understand when the accused said that Aaron sudah mati dan kita tanam di pantai?
What I understand with the statement is the accused told us that they already killed the victim. And I understand that Aaron is the one who was kidnapped by them.
Alright, no further question, Your Honor.
Ms. Huda, you may step down. Any additional witnesses on behalf of the public prosecutor?
The prosecution rests.
Defense counsel, does the defense wish to call any witnesses?
The defense calls for the defendant, Mr. Haniff. Mr. Haniff, is it true that you borrowed a motorcycle from a person named Mr. Shin before 3rd May 2004?
Yes, I did.
When did you return the motorcycle back to Mr. Shin?
I returned the motorcycle on early April.
When do you start get to know Justin?
Met him in November 2002 at the workplace.
Are you and Justin probably a good friend?
I hardly knew Justin.
By any chance, Mr. Haniff, have you ever met Justin past 10 at night?
No, I didn't.
On 26 April 2004, were you at the hardware shop at 5:30 p.m.?
No, I didn't.
On that day, did you buy the nylon rope?
No, I didn't.
Okay, no further question, Your Honor.
Cross-examination, public prosecutor.
So, Mr. Hanif, you told the police that Aaron sudah mati dan kita tanam di pantai, wasn't it?
No, I didn't.
So, Mr. Hanif, you did purchase the green color nylon rope from the hardware shop where you work, didn't you?
No, I didn't.
Then, Mr. Hanif, on May 4th, 2004, you admitted that there was some amount of ransom money hidden in the bathroom in your rented house, didn't you?
Yes, I did.
You brought the police party to your house at number 36 Lorong Aibude and showed them the orange plastic under the sink and told them the money was in there, right, Mr. Hanif?
Yes, I did.
Mr. Hanif, you brought a police party comprising SP8, SP9, and the police personnel Muhammad Noor to a beach situated behind Squash Court MBK at Taman Teruntum, Kuantan, the place where the deceased was found died, didn't you?
Yes, but I didn't kill him. Do you blame me?
Yes, I blame you. No further question, Your Honor.
Mr. Hanif, you may step down. Defense counsel, any additional witnesses?
The defense rests.
We will now hear closing arguments of counsel. Public prosecutor, you may proceed.
The evidence is undisputed that the defendant, Mr. Hanif, is found guilty for the deceased death. The evidence shows that Mr. Hanif has clearly stated, itu Aaron sudah mati, kita tanam di pantai. Next, ada evidence that shows Mr. Hanif, the first accused, has killed the deceased when the deceased was found buried at the beach with his hand tied with a green nylon rope, where the first accused had admitted before that he bought that nylon green rope, and it has been witnessed by another witness. You, Mr. Hanif, also prove us that you are guilty of kidnapping the deceased when you successfully showed the police party the ransom money hidden in the bathroom at your house. Furthermore, the first accused managed to show the police party where the deceased was buried. All of these are clear evidences where the first accused, Mr. Hanif, can be convicted of kidnapping and murdering under Section 302 of the Penal Code, right together with Section 34 of the same code for having murdered a 17-year-old kidnapped victim, and under Section 3 of the Kidnapping Act 1961, right together with Section 34 of the same code for kidnapping the victim for a ransom of 20,000 ringgit Malaysia. Ladies and gentlemen, this isn't only a case of kidnapping, this is also a murdering case. All has been proven to the court, therefore I submit that Mr. Hanif is guilty of kidnapping and murdering the deceased, Aaron. That's all, thank you.
Defense counsel, you may proceed with your closing argument.
Your Honor, my client Mr. Hanif is not guilty of this charge. The fact that the witness, who is the boy's mother, cannot identify the face of the caller proves that Mr. Hanif is not the one who murdered her son. Then, Mr. Hanif had given back the motorcycle to Mr. Shin in early April, which shows that he was not the one who used the motorcycle on 29th April 2004. Furthermore, the first accused, Mr. Hanif, did not have any close relationship with the second accused, Justin, neither a good friend nor a best friend. So the possibility of them to do the act together is irrelevant to be said. Moreover, the entirety of the report of the chemist also is found to be neutral. All of this evidence shows that Mr. Hanif is not guilty for kidnapping and murdering the boy Aaron.
So, in the light of the attempt to introduce fresh evidence at the stage of the case for the defense, it cannot be said that the prosecution in respect of the charge pursuant to Section 302 of the Penal Code has discharged its legal burden. Moreover, the statement cite the conduct of either accused, the first and second accused, where they have purportedly appointed to the spot, cannot be taken as corroborative that they have acted in concert to the cause the death of the deceased. I do not take into account photograph taken by the police team showing that the first and second accused pointing to the body. The pointing was clearly done on the instruction of the police. Having further considered the evidence, I find that the defense has raised a reasonable doubt in respect of the charge under Section 302 of the Penal Code, thereby entitling them to an acquittal. The legislator itself has deemed it appropriate to provide an alternative. I take into consideration that both the first and second accused do not have any previous criminal record. Accordingly, I exercise the discretion to impose a sentence of imprisonment for life for each and 10 lashes each of whipping. The sentence of imprisonment is to take effect from the date of arrest. Thank you everyone for your cooperation and contribution. Court is adjourned.